The Honorable, the Vice President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implication into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the Vice President.
Honorable Senators, I wish to advise that Christine Kangaloo is out of the country, and leave of absence has been granted to Senator H.R. Ian Roach, who is ill. Honorable Senators, I have received the following correspondence from His Excellency the President, Anthony Thomas Aquinas Carmona, ORTT, SC. The Constitution of the Republic of Trinidad and Tobago, by His Excellency Anthony Thomas Aquinas Carmona, ORTT, SC, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Ndali Young. Whereas Senator Christine Kangaloo is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndali Young, to be temporarily a member of the Senate with effect from the 13th of June 2017 and continuing during the absence from Trinidad and Tobago of the said Senator Kangaloo, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 12th day of June 2017. To Mr. Nikolai Edwards, whereas Senator Hugh Russell Ian Roach is incapable of performing his duties as a senator by reason of illness, now therefore I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Nikolai Edwards, to be temporarily a member of the Senate with effect from the 13th of June 2017 and continuing during the absence of Senator Hugh Russell Ian Roach by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 12th day of June 2017. Honorable members, senators are required to take the oath.
I, Ndali Young, having been appointed a Member of Parliament, do solemnly affirm that I bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
Having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Papers.
Leader of Government Business.
Thank you, Mr. Vice President. Mr. Vice President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The annual audited financial statements of National Flour Mills Limited for the financial year ended December 31st, 2016.
Reports from committees.
Senator Samuel.
President, I have the honor to present the following report as listed on the order paper in the name of the Honorable Paulo Gopiscone. The first report of the Joint Select Committee on Foreign Affairs, second session 2016-2017, 11th Parliament, on the public examination of the draft summary of recommendations and conclusions of the 41st meeting of the Council for Trade and Economic Development.
Urgent questions.
Mr. Vice President, we have a small challenge this morning. The urgent question was circulated extremely late, if I should say so. And we would like to stand on the questions to the Minister of National Security and Education, but we are in a position to answer immediately the questions to the Minister of Labour, Small Enterprise and Development. I hope that meets your approval, sir, with the consent of the House.
Honourable members, question number 2 would be stand down as indicated by the Leader of Government Business, and we would move on to 1, 2, and 5 would be stand down as indicated by the Leader of Government Business. So we'll move on to question 4. Senator Mark? Question 3. Question 3, sorry. Senator Mark.
Mr. Chairman, before I... Mr. Vice President, question number 3 to the Honourable Minister of Labour and Small Enterprise Development. In light of the explosion of an ammonia gas cylinder and the death which resulted from the incident, has this matter been investigated by the OSH authority with a view to preventing a reoccurrence.
Minister of Labour and Small Enterprise Development.
Thank you very much, Mr. Vice President. A pleasant morning to all my colleagues. Mr. Vice President, in response to the Honorable Senator Wade's urgent question, which was really urgent, you received it a short while ago. Nonetheless, Mr. Vice President, I'm informed that the matter is being investigated by the OSH agency. The investigator visited the compound on Friday last, which was the 9th of June, and interviewed the management of Massey Gas Products. And the agency is in the process right now, as we speak, in collating the evidence with a view to determining if any areas of the OSH legislation was breached. And that visit was made to Massey Gas Products in Point Lisas, Mr. Vice President.
Senator Mark.
Yeah, thank you. Mr. Vice President, could the Honourable Minister indicate how soon that OSH report would be submitted by the officials who are currently executing investigations?
Minister of Labour and Small
Thank you kindly, Mr. Vice President. As a matter of fact, the OSH agency is in the process of conducting a full inspection of the entire compound of Massey Gas Products to ensure that not only the area where, unfortunately, the fatality occurred, but the entire operations of that company. And in that context, Mr. Vice President, the government of Trinidad and Tobago extend our really sincerest condolences to the family of this young man who, through no fault of his own, lost his life during a particular operation. In response to exactly when the report is going to be submitted, I cannot give you that information, but through you, Mr. Vice President, I could assure the Senator that once it comes to fatality, the Executive Director of the OSH agency makes sure that the inspector, whichever inspector is assigned to investigate, submits that report within the specific time frame that I don't have at the moment. So I give you that assurance that those reports are submitted. And I can also add, Mr. Vice President, that the OSH agency have been laying charges against companies, and companies have been fined and paying up those fines. In addition, we are in the process of beefing up the staff at the OSH agency because their role is so vital to the maintenance of the health and safety of workers of this country.
Senator Mark.
Thank you, Madam. Mr. Vice President, I beg your pardon. Could the Honourable Minister indicate to this Senate whether the financial obligations that the company, Massey Products Limited, would have to the family of the dead person under the Workmen's Compensation Act? Could you indicate to us whether that has been met by the company?
Minister of Labour and Small Enterprise.
Mr. Vice President, I am not seized of that particular information that the Senator seeks, but I can always request that information from the Executive Director and to bring it back to this Honourable House.
Senator Mark, next question.
Thank you, Mr. Vice President. Mr. Vice President, to the Honourable Minister of Labour and Small Enterprise Development. In light of the recent incident at the National Flour Mill feed mill facility, which resulted in the death of an employee, can the Minister indicate if the NFM is fully compliant with its safety obligations as an employer under the Occupational Safety and Health Act?
Minister of Labour and Small Enterprise Development.
Thank you very much, Mr. Vice President. Mr. Vice President, in terms of the recent fatality at National Flour Mills, where the employee died 3 days after he fell. I am informed that the area where the incident occurred was inspected and it was found to be fully compliant according to the law. However, the particular inspector is in the process of inspecting the entire compound, not only the area where the fatality occurred. And that inspection was done yesterday, Honorable Senator Wade Mark. The incident occurred on 8th of June and the employee died on the 11th of June. He fell down the external metal staircase. He was transported to Sinclair Medical Facility on the same day. He died following surgery on Sunday the 11th, and OSH agency is awaiting the medical report to determine the cause of death. Thank you, Mr. Vice President.
Senator Mark.
Thank you, Mr. Vice President. Could the Honourable Minister indicate to us what kind of counselling has been extended to his fellow workers having regard to that incident in which the gentleman died? What kind of counselling has been extended to the remaining workers who obviously would be traumatized by this incident?
Minister of Labour and Small Enterprise Development.
Mr. Vice President, I am aware that given the Senator's similar background to mine, that he would be very concerned about the mental state of the employees. But regrettably, the OSH inspector, that does not form part of his or her legal requirement. However, I would hope that National Flour Mills has in place a program to offer the workers the necessary psychological and other forms of counseling.
Will I see
Yes, I was just going to inform you that the Minister of National Security is here and he's in a position to answer questions 1 and 2. Yeah.
Senator Mark.
Thank you, Mr. Vice President. To the Honourable Minister of National Security, given the plea by the President of the Police Social and Welfare Association for the provision of non-lethal equipment for members of the Trinidad and Tobago Police Service, does the ministry intend to support this request, or would you support that request as Minister of National Security?
Minister of National Security.
Thank you very much, Mr. Vice President. The direct answer to the question would be yes. However, the operational use of the Trinidad Police Service comes under the Commissioner of Police, and he has advised me that they are in fact revising the use of force policy to include the use of non-lethal weapons. And he's prepared to budget for fiscal year 2018 to deal with that procurement. So they are in fact revising the policy right now. So a direct answer in terms of supporting that. Because when you look at around the world in terms of use of force, you have a certain kind of progression. So therefore you start with non-lethal weapons and before you get to lethal weapons. So the ministry is prepared to support it based on the recommendation of the Commissioner of Police.
Senator Mark. Thank you, Mr. Vice President. Could the Honourable Minister indicate to us when he expects this policy to be completed, this non-lethal use of, force policy?
Minister of National Security.
Thank you, Mr. Vice President. I cannot give you a timeline, but I know from the Commissioner of Police, they're working on revising that use of force policy. And if, based on what he said in terms of preparing for fiscal year 2018, I would expect it would be done in preparation for that timeline.
Senator Mark.
Thank you very much. To the Honourable Minister of National Security. In light of reports of a bomb threat at the Scarborough port and the resulting chaos, what urgent measures have been implemented to heighten security at the nation's port?
Minister of National Security.
Thank you very much, Mr. Vice President. So, Vice President, the Trinidad Police Service are in fact investigating the bomb threat at the port. And last month, the Ministry of National Security met with the Tobago House of Assembly. In fact, all the agencies, we had an all-around meeting dealing with security aspects in Tobago, in addition to the ports both from Port of Spain and Scarborough. Among the measures that we came up at that meeting, and which is being pursued by the DCP Crime right now, is to include the use of K9 at both ports Port of Port of Spain and Port of Scarborough, and those canines are in fact not only bomb detection but narcotics detection dogs that will be utilized. DCP Crime has also informed me that he has assigned additional manpower to Tobago to treat with issues of security, not the port alone, but throughout Trinidad and Tobago, inclusive of the ports.
Could I ask the Honourable Minister whether the canine unit or canine animals that are going to be at least allocated to the port or utilized at the port, could you indicate to us when that will take place, or has it already taken place?
Minister of National Security.
Mr. Vice President, it has not taken place as yet because they are in fact locating the appropriate kennels for Tobago in collaboration with Tobago House of Assembly. Once that is done, then the dogs will be assigned to Tobago. However, they're going to be starting using the dogs from Trinidad and Tobago. I can't give you a timeline, but that is due to start soon because the dogs are here in Trinidad. So they can at least use the leg at the Port of Spain port to do the necessary checks before people board, passengers and vehicles board the vessels.
Senator Mark.
Honourable Vice President, through you to the Honourable Minister, is any attempt being made to expedite the construction of the kennels to house these canines?
Minister of National Security.
As I mentioned, that's being based again on the discussion that we held with Tobago House of Assembly. But what I can say is in that the building of the new police stations, we intend to have various areas allocated for canine in Tobago. Yeah.
Honourable members, that brings us to the end of urgent questions as the 10 minutes has expired.
Public business, government business, bill, committee stage.
Honourable members, the committee stage of the following bill, which was in progress when the Senate adjourned on June 8, 2017, will be resumed. A bill entitled An Act to Amend the Offences Against the Persons Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. The Senate shall now go into committee. Honourable members, I just wanted to indicate that on the last day when we sat as a committee, clauses 1 and 2, question was put and it was put as it stand part of the bill. So we'll move on to clause 3 and begin from there. I would invite the Attorney General to make some introductory remarks. Attorney General.
Thank you, Mr. Vice President. Honourable members, just by way of encapsulating what's before you, you'll recall that we had some very, very important and very constructive proposals come from the opposition bench in particular relative to the opportunity which we have to treat with a lacuna in the law, which Senator Ramdeen identified for us coming out of the Chuck Atin case. The Chuck Atin case is the leading Court of Appeal decision which treats with how a court deals with someone who's under the court's pleasure. Now, Mr. Vice President, the reason I'm explaining this is that the lawyers in the room would understand these things, but it may be difficult for others, so I'm just trying to put us into the same frame. You are under the court's pleasure in two circumstances. So if there is a finding of guilt and two circumstances arise, you're put under the court's pleasure. In the first circumstance, it's where you're a child. In the second circumstance, where there's some form of mental capacity issue. Over time, you can change in those circumstances. In particular, in the mental capacity issue, you may find yourself improving or deteriorating. What Senator Ramdeen pointed out for us was that there was a difficulty, which was exemplified in the Chuck Atin case, in persons actually coming back before the court. So the first thing is that the old language, which we were amending, repeated the old law, which was not shown on the books. President should have been changed to court. So it's no longer the president's pleasure, but it's the court's pleasure. But secondly, there were these directions given by the Court of Appeal in the Chuck Atin case, where the court said what you should take into account, what is the best kind of practice to come forward back to the court. And what we have is an opportunity now, which is reflected in the draft before you, to take care of what the existing law is in the Court of Appeal dicta. And that finds itself into the amendments which we have recirculated, and the differences in the recirculated amendments really appear at page 2, where we begin to talk with the introduction of new subclauses 7, 8, 9, and 11, 12, and 13. And what this is that it lifts out of the Chuck Atin case what the court sets out as criteria. I had an opportunity, not in the best and most fulsome of ways, to touch base with the judiciary and with some members of the criminal bar to have a discussion about some of the issues there, and there seems to be comfort with it. The other factor, and again, I thank Senator Ramdeen for raising this, is a potential lacuna in the Children's Act, because we have in the new section 59 of chapter 12 of the Act number 12 of 2012, there is silence in respect of how we treat with minors, which has found itself here. We've looked at it. We don't have the opportunity to amend the Children's Act in this bill because it would be too far out of the scope of this, and therefore it wouldn't be a consequential amendment. But the good news is that we're actually working on a host of amendments which we've nearly finished at the Legislative Review Committee, which will treat with that to clarify the position in law in the event that one can argue that there's a lacuna, because the court can always fill the vacuum of its own volition. Specifically, the other issues which we traversed in general discussion included providing a time frame for the judiciary to give a judgment. Again, I had conversations with both the criminal bar, members of the criminal bar, not the association itself, and certain members of the judicial background, because it comprised both administrators and judges, to look at that position. And the general sentiment was agreement that there be a time frame, particularly because we're talking about someone's liberty, as opposed to a civil matter where perhaps liberty is not an issue, but maybe just as offensive. So you will see in here improvements in the time frame for a description as to when a judge should give decisions. But we've allowed for a window where the judge can actually come back to court if the time frame isn't working, call the parties in and say what the new time frame is, so there's always a clock. So that's in overview some of the improvements that we've had. We had to work till late into the night. I reached out to Senator Ramdeen. I couldn't, of course, reach out to all to have informal discussions so that we could sort of clarify our minds. And I thank you, therefore, Mr. Vice President, for just giving that general introduction into what is before us. Senator Choate had raised one issue, and I don't see her here, but I'll put it on the table, as to whether there was a potential incongruity in the criminal proceedings rules timeframes versus the bill. And we've checked, and there isn't any. And of course, we sought to treat with the forms which were used to indicate someone's consent to go either judge or judge only, or judge and jury. And we've also provided for a tightening up in the transitional provisions. But we can come to those, if you please, Mr. Vice President, in whatever fashion the Senate wishes to come for further explanation. So that's the opening remarks, and thank you for the opportunity.
Thank you. Honourable Senators would remember at the last sitting, Madam President would have reopened Clause 3. So what I propose to do is to put the question again for Clause 3, invite comments from Honourable Senators, and we'll move forward clause by clause at this committee stage. So the question is that Clause 3 be amended as circulated.
Mr. Vice President, I would need to go through those particular sub-items now, and then through you open the points. We propose to amend Clause 3, firstly, and we've provided senators with a track change version of what the bill looks like, together with what the formal amendments look like when one circulates. So we're proposing an amendment to Clause 3, where the first amendment is that we amend Section 4A. We are, in the first instance, in that first Roman 1, we're taking care of the observation that one can no longer have the words, the President's pleasure, and we're amending it to read the Court's pleasure. And that's to be found literally at the penultimate, the third from last and penultimate lines of the paragraph, that the Court may order such person to be detained in safe custody in such place and manner as the Court thinks fit until the Court's pleasure is known. So that's the first observation, and that was to address the issues raised by both Senators Ramdeen and Senator Shriki Soon in the course of debate. In subclause 2, we originally were going to delete the offending language which judicial pronouncement said was ultra vires, unconstitutional. That clause was the clause that couldn't be saved and which the Law Reform Commission had not picked up. It's in this place here now that we have the opportunity to import what is called the Chuck Atin directions, which is the dicta of the local court of appeal in dealing with how one is to be monitored whilst in the court's pleasure and how one finds oneself back before the court, because the reality is that you had to fight your way back into the court's attention as opposed to coming up automatically. So the new subclause 7 reads such that the court makes an order under subclause 6, that's where you're under pleasure. The judge shall determine what he considers to be an appropriate minimum sentence to be served and give his reasons, straight out of Atin. In subclause 8, we now get into some of the prescriptions as to what the judge should take into account. And we say that the appropriate minimum sentence pursuant to 7, the judge shall take into account, and then we start off with the dicta coming out of Atin in subparagraphs A to D, so as not to tie up the law and to allow it to be a living, breathing entity. We've included a subparagraph E, which allows for any other relevant matter to be taken into effect and into account. The new subclause 9 would describe for the purposes of 8D what aggravating factors shall include. Now, include is the language that you use, where again you want to not prescribe the court to only these matters, but where you can leave the door open for the judiciary to grow the law up. And then we take into the positions for aggravating factors. In subclause 10, we're looking at the converse, which is the mitigating factors. And again, we use the language include. When we come to subclause 11, we say an order under subsection 6 shall be reviewed by a judge of the High Court every 3 years, or such shorter intervals as the court may in exceptional circumstances ordered. That's to take care of the fact where the court might actually make an order which is less than that. But we've put a minimum marker. I should say the prisons preferred 4 years, but the bar and bench were happy with the 3-year proposal, which is resonant with the language in the Atin case, which prescribes 3 years. Subclause 12 deals with the purposes of review. In 12 and 13, we're actually going to provide that the Commissioner of Prisons or the head of the institution. Let me explain those differences. If you're at the court's pleasure, you can be actually incarcerated under the command of the Commissioner of Prisons, or you can be under the Chief Medical Officer if you're at St. Anne's or some other health institution, etc. So we had to use two forms of language to capture the person who shall provide information on a continuous basis, and in this instance yearly, to the Registrar of the Supreme Court. And we're saying that you should provide information annually in respect of each year following the making of an order and transmit the documents to the Registrar of the Supreme Court. And the matters are a full report addressing conduct, response, attitude, response to moral or religious teachings, and containing such recommendations for guidance of the court as the Commissioner of Prisons or the head of the institution may think fit. Subclause B, an up-to-date medical report from either one of the two supervisory entities. Then we go, such other information derived from the record of the case or otherwise as the court may require, again allowing for the breadth of the law to develop. In subclause 13, the Commissioner of Prisons or the head of the institution shall ensure that the information provided under 12 and relating to the progress and development of the person is generated at yearly intervals by the appropriate department in the prison or institution. We have had a conversation as we are developing the prison's rules, which are being implemented on a stage basis, to take care of the administrative difficulties which prisoners often have in getting what they have signed, whether by way of request or otherwise, to the attention of the court. So the prison's rules are intended to take care of the administrative workings of getting the documentation between the prisons and the court. Under subclause 14, the Registrar of the Supreme Court shall forward the documents referred to in 12 to the Chief Justice, who shall assign a judge of the High Court to review the matter as required under subsection 11. So what we have sought to do is to capture the guidelines in the Chuckatin case and then look at it from a prescriptive point of view and an administrative point of view, and therefore, instead of repealing the subclause 7, now provide the mechanisms by which one can approach the court. Mr. Vice President, subclause 3 includes further amendments. Sorry, actually no, the next one will be 4A. So those are the proposed amendments to clause 3 of the bill, and hopefully I've given some indication of what the thinking behind it is, but I welcome the views of the Senate through you, Mr. Vice President.
Do we have any further comments by any other
Yes.
senators? Senator Mahabir?
Okay. Yes, thank you very much, Chairman. I know Senator Ameen is taking the lead on this, but I've just received these, Mr. AG, and I'm looking at some of the language, and I'm wondering whether it would not be beneficial to look at the language from our angle a little carefully. Take 9, for example, and I'm seeing 9B, taking advantage of an elderly or disabled victim. I would have thought that taking advantage of a senior citizen or differently abled victim would read better. And when I look at 9C, you look at mental disability, I would have thought the word mental illness might have been more precise and appropriate. So I am just picking up these things on the fly, as it were, and I don't know if the lawyers here have the view that we could look at it a little carefully to see how we can tighten up the language to make the law a bit more precise.
There would be no objection to improving the language.
Senator Ramdeen?
AG, morning. Thank you for taking on board, first of all, the suggestions that were made. And I can say that what we have before us is a much more improved version of the bill. There are one or two things that I wish to perhaps point out that could be of benefit to all of us. First of all, when Atin was done in the Court of Appeal, I mistakenly failed to mention to you that after the substantive judgment was given, there arose some issues that we wanted the court to clarify. It was done by a question and answer conversation with the Court of Appeal. We had submitted on both sides, the Director of Public Prosecution and the appellant, a number of questions that we wished that would have made the process tighter. I'm not sure if Mr. McIntyre and your team had been able to get a sight of it, but I want to pass a copy of that to you.
We haven't, and thank you. You had mentioned that to me yesterday as well. Thank you.
When you see it, and I apologize, perhaps, Mr. Chair, it would be probably more beneficial for us as a parliament to work that when we have material like this, we can pass it to someone so that it could be given to all of the senators so that they could see what we're sharing with each other. It really is unfortunate.
So they can make copies.
Yeah. I would really, just on these points, AJ, I would really, if you would join me in probably asking if we could get some copies made so that at least the other parties can see what we're speaking about instead of having it in a vacuum.
I think they've gone to do it.
Okay. So can I proceed in
Yes,
the
please.
meantime? That judgment, just give me in the meantime. If you could give it there. No, let him have it. Let him have it. Let him, that's the same thing. Let him have it.
That's the same thing?
Yeah, let him have it. So you
Could
see
you
what I'm
pass it
talking
on
about.
to the AG? Yeah, the other one will be copied, so at least you'll have something before you.
Thank you.
Whilst they're making copies.
Looking. Mr. Vice President, excuse me. I just wondered if the AG could clarify this section. Killing a person providing a public or security duty. Is that specific to, sorry?
Senator.
Sorry.
Richard, sorry, could you just identify the section specifically for other?
The same 9, Part D.
Yeah.
Killing a person providing a public or security duty. Is that specifically referring to state public or security duty?
No, it's meant to be broader. We lift it from the language of the judgment itself. So it isn't intended, it's meant to capture the variety of circumstances that can arise in a case-to-case basis. So it would be improper to just focus it only on the public authorities, because private authorities, which are of a large or even small type, clearly defending oneself and attacking somebody who's in the course of defense is something to be considered by way of aggravation. Senator Ameen, I have the question and answers before me now.
What I suggest, AG, is that the team actually consider not having seen this before, because you would see straight away when you start looking at the questions that the questions actually explain what arises out of the judgment. I'm not saying that everything there needs to be lifted and put into the legislation, but there are one or two things there dealing with the issue of the working of Rule 285 for persons who are incarcerated. That is a very important thing because it impacts upon the timelines that are set in the legislation as you have it already.
Yes.
So I would appreciate if you take some guidance from it.
Sure.
And the team takes some guidance from it, because even the library didn't have it this morning, so I had to get to the librarian to get a copy, because it's not, when you look at what is reported on the Webber Park, it's not there.
So perhaps, Mr. Vice President, whilst we as a team, the technocratic end of the team, look at this, because it also coincides with the sentencing guidebook issued by the judiciary in terms of the calculation of time, which came subsequent to this, which is equally useful. Perhaps we can look at this if any other senators, Senator Ameen, of course, and other senators had any other observations on this particular clause, we could perhaps take this as a group, and whilst we are proceeding with the rest, we can work on it in the meanwhile.
Sure. When Atin was decided, AG, what had happened is that Atin was the first time that the law, as applied by the Privy Council in the other cases, and as applied in the United Kingdom in V&T, had really been challenged in our jurisdiction. When the law was challenged in the United Kingdom, what transpired is that they issued 2 practice statements dealing with how these persons were to be reviewed. Now, I'm going to get to one of the questions that Senator Richards raised. And what I want to point out to you is that when we had gone to the Court of Appeal, the law was in the state of actually being crafted as to what would be aggravating and mitigating factors. From the practice direction that was issued by the Lord Chief Justice Lord Wolf at that time in the United Kingdom, they had a very more expansive, going to the point that Senator Richards is making, definition of what should have been the aggravating and mitigating factors. And they had identified 11 aggravating factors, some of which I think we ought to take on board having regard to the nature of the kinds of killings that we have in this country at this moment, which has only really gotten worse. But I think when the Court of Appeal, and I understand your reason for lifting it out, and perhaps you would need to take these on board, but just for the purposes of the Senate and the committee, if I can just read them out so that everybody will have the benefit of it, and I can pass it to you thereafter. And they also had the prohibition of saying that this is not an exhaustive list as well. Without seeking to be comprehensive, aggravating features will include 1, evidence of a planned or revenge killing. That takes into consideration A. So you have planned and premeditation. Perhaps you may want to consider the word revenge. 2, the killing of a child, and this is to take on board what Senator Mahabe had said. The killing of a child or a very old or otherwise vulnerable victim. So it casts the net a little bit wider than what we have here. 3, evidence of a gratuitous violence or sexually maltreatment, humiliation, or degradation before the killing. Killing for gain in the course of a burglary, robbery, blackmail, insurance fraud, etc. 5, multiple killings, and that is, I think, something that we need to take on board because of our experience, AG. 6, the killing of a witness or potential witnesses to defeat the course of justice. That too is something that is very frequent in our law. 7, the killing of those doing their public duty, and then they go on to define, as Senator Richards had pointed out, police officers, prison officers, postal workers, firefighters, judge, etc. We may want to be able to expand the net in that respect, but also be able to add wherever we think possible. Terrorists, a matter that you are dealing with now. Terrorism or politically motivated killings. I think that is something having regard to the development of the law that we need to take on board. 9, the use of firearms or other dangerous weapons, whether carried for defense or offensive reasons. And attempts to dismember or conceal the body. That is another matter that has unfortunately found itself in our jurisdiction. Those 11 factors, AG, as set out, I'll pass the practice direction to you, is something that I think if we pass it around to the senators, we may be able to agree on a more comprehensive list that will expand the net of the aggravating factors. Because
May I invite, sorry to interrupt, through you, Mr. Vice President, may I invite your thought on, there are 2 ways that we can go. One is prescriptively, or as bare bones prescriptively as we can, and those are some very, very useful observations coming out of the English experience. But the second route that we can do is, in fact, by reliance upon the sentencing guidelines as the judiciary has now published, practice directions and sentencing guidelines. So we could have gone for the more framework end of it, which is the latter end of what's just been referred to, or be prescriptive. I think we're at the juncture where it's open one way or the other. You'll see in the plea bill, not that I'm anticipating it, that we've taken a slightly different approach, but more because that was of a contractual nature rather than a prescriptive judicial consideration or factor nature. May I ask what the view is in relation to which one of the options?
I much prefer, AG, if we are legislating, I am not comfortable because being an advocate in the courts, the sentencing guidelines, both in civil, because you have a civil version, you have a criminal version. I'm not comfortable with just having those books published by the Judicial Education Institute, and it is a step forward in the right direction. But my experience in the courts is that the experience before the courts as an advocate is such that it is so subjective according to which judicial officer you go before. I think that it is much better if we are going to fix it as a parliament, we lay it down in law and then allow the courts to determine, without leaving it to the common law then, to simply let a judicial officer think what they consider to be the mitigating or aggravating factors. I much prefer that as a parliament we do fix it and lay it down in law. If the judges, it would then provide a proper statutory framework for the judges to then exercise their discretion one way or the other. And when you lay it down there, it always leaves open the point that you're making, a matter of weight as to how much weight you would put on each factor. But at least let us have it so that anyone coming before a court doesn't, any accused coming before a court doesn't have the risk of suffering from a judicial officer not casting their mind on a factor by virtue of perhaps not reading a case or not reading the sentencing handbook. That is my view, subject to what anyone else may have to say.
Appreciate it. Thank you.
When we go on to 10, with respect to the mitigating factors, practice direction also sets out a more comprehensive list, which would include 1, the age of the defendant, subnormality or mental abnormality, provocation in a non-technical sense, excessive response to a personal threat, the absence of an intention to kill, spontaneity and lack of premeditation beyond that necessary to constitute an offense, for example, a sudden response to family pressure or prolonged and eventually insupportable stress, mercy killings, a plea of guilty, and hard evidence of remorse or contrition. And those, I think, AG provides a very good list that we can use. I will pass this to you, and you can then distribute to the honorable senators.
Appreciate it.
Yeah, my friend, my colleague is also indicating to me that an accused character is something that is very relevant in relation to a mitigating factor as well. Perhaps the character will encapsulate not only good character in terms of a lack of a criminal conviction, but their participation in the community, whatever social work they might be involved in. Those are things that are prevalent in our jurisdiction. Out of that as well, AG, there was a second practice direction that was issued by the Criminal Division of the Court of Appeal in the United Kingdom at 2002-3 All England Reports at page 412. And I wouldn't go through it for the sake of time, but I will also pass this to you so that in this this particular practice direction was issued pursuant to the decision of the European Court in Venables and Thompson and the United Kingdom, where they had struck down the initial sentence of those 2 children, 9 and 10, that were involved in the killing of Jimmy Bulger. That this practice direction also contains a number of mitigating and aggravating factors. It goes on to deal with the issue of a starting point for these types of cases. I don't wish for us to legislate a starting point in any of these kinds of cases. I think that really is a matter that is purely judicial and not properly to be left to the judiciary. But what it does is that it does explain some of the aggravating and mitigating factors that are found in the first. These are particular to young offenders in relation to your juveniles. So it may be helpful in this, and it may also be more helpful in your attempts to fix the legislation with respect to the Children's Act. So I pass that to you as well. AG, one of the things that I have a little bit of a concern about that goes back to section 7 is the way in which, and I understand that this is a working draft that we're working with. When these provisions are lifted out of the Act in Appeal and the guidance of the Court of Appeal, one thing that we ought to be careful about how we're dealing with the legislation is that this would have been in relation to young persons, and what you are dealing with is with the offenses against the person. The difference that I tried to explain on the last occasion was that I'm not comfortable in section 7 with the use of the word sentence to be served, and it may sound as a technicality, but I'll explain to you why I'm not comfortable with the word sentence. This is in your subsection 5.
Yeah.
4th line starts off sentence to be served. The issue with the abnormality of mind cases, Attorney General, is that you have different degrees of abnormality that someone may suffer from when an offense is committed. So when the law goes back to the original, when the sentence was originally framed, it was encapsulated in the judgment of the criminal court in the case of James Hadfield and the Queen. And what had happened in James Hadfield was that Hadfield was mad and he went and shot at the king, which was treason. At the time that he did that, which was before 1800, there was no legislation in place to deal with persons who were insane, and therefore Hadfield had to be set free, even though there was no way in which because he wasn't guilty of an offense, because he couldn't have the mens rea being insane. And then they enacted in the United Kingdom the Insanity Act. Is not I don't have the right name now, but the Act of 1800, and that started the statutory intervention into these cases. The reason why I'm saying that is because of the different degrees of abnormality of mind that you have in these types of cases. You would have persons who may just border being able to have the mens rea, and then you will have someone who may suffer from like schizophrenia, which is the most common one of the illnesses that these offences cater for, who will be totally insane at the time that the offence is committed. I think that perhaps it will better be a better term for us to use in relation to the Offences Against the Persons Act would be an order of detention to be served. The reason why is because when you have the word sentence, it connotates a certain amount of guilt, and you would have a degree, you would have in these cases persons who have varying degrees of guilt. And what you are really doing is the court is not really making an order for a sentence of a particular term, but is really making an order of detention that is reviewable by the court over a period of time. So I would much prefer if we use the term an order of detention to be served and give his reasons. I see that in relation to that particular section, AG, unless I missed it, is it that you intend that you fix a time period for the giving of reasons in relation to that? Because if that is the case, I don't see any reason why in giving, in these particular cases, unlike the circumstances you had before, these are cases where somebody is going to be incarcerated following the sentence. So if you're fixing a term, I don't see any reason why for these purposes they don't give their reasons immediately upon or shortly thereafter the setting of the tariff. So that may be a subsection that you may want to consider in relation to subsection 7. One of the things that you would want to consider, AG, is that if you look at the Act number 2, the basis upon which you had indicated, or the policy, perhaps better said the policy behind which you had indicated that there was a difference between an acquittal and a conviction was the right of appeal. You would see very interestingly that in the question and answers that was given by Chief Justice Sharma, he said that this is not a matter that is subject of a criminal appeal. There's no right of appeal from the minimum sentence, even though it was done in relation to Atin. So it will have to be part of the criminal conviction process instead of the actual saying, I want to appeal the minimum sentence. So that is something that perhaps you would want to consider in relation to that. What you would want also to consider, Adrian, this is something that I want to really stress that we consider carefully as a parliament, as a matter of pure public policy and in relation to fixing these matters. I have a real difficulty, Adrian, in the fact that we've left open the idea, as the law had allowed initially, to be detained in safe custody in such place and in such manner as the court thinks fit until the court's pleasure is known. The experience that we have had in this jurisdiction, AJ, will be borne out by the decisions of the courts and your advisors in the prison service. It is very unfortunate that we treat with our mentally ill persons in the manner that we treat with them, especially in these types of cases. The prison is not a place, especially our prisons, is not a place for any mentally ill person to be. And the first reason why I would say that is because there are no facilities at the prison to treat with persons who are mentally ill. There are two particular individuals who are flaming mad at the Port of Spain prison who have absolutely no reason to be there, and they are just simply there, sitting there, rotting away. And that cannot be right. It is wrong for the courts to treat with these matters because usually before this sentence was opened up by the courts, they treated it normally as a life sentence. So you just put them in prison, you don't bother to review them. You have these 4 yearly reviews under Rule 281 and 282 of the prison rules, and the courts have also held that that review is not what is required here. We need to put something in place. I don't know if you want to consider that you may want to give yourself or the Minister of National Security the power to make some type of regulations I don't think that what I'm suggesting is something that would properly to form the basis of principal legislation. But you may want to give the Minister of National Security, as you've done in the plea bargaining legislation, for fear of anticipating that, but you've inserted there in your amendments from the House a power to give yourself in that particular piece of legislation the power to make regulations and to submit a report to the Parliament. I don't really see the need to submit any report, but if we can insert a power to make regulations and side by side with the prison rules, we are able to allow the minister in charge of the prison to make regulations, or yourself as the guardian of the public interest to make some regulations to deal with this matter. I think is something that will be of substantial benefit both to those people who may be subject to this type of sentence or to those persons who are already there, because there are persons who are already there who we still may be able to provide some benefit to. So I would want to ask that you consider doing that, because there is a benefit to saying leave it to the court to detain the person in safe custody in such place and in such manner. This term in safe custody in such place and in such manner is actually lifted out of the old 1800 Act. I think we've come a long way from there, so that we have an institution that looks after mentally ill people. If there are persons who suffer an abnormality of mind and suffer from a mental illness, the actual prison is not the place for them to be. But like I said, I think that is something that we could deal with in terms of some type of regulation. You would want to consider the application of Rule 285 in relation to subsection 11. What can be argued is that in relation to persons who fall under the Offences Against the Persons Act, whether it is 3 calendar years or 3 years calculated in accordance with the remission provision under Rule 285. The difficulty with that is that I think that you should be complimented for actually addressing the issue that these reports be generated on a 1 yearly basis, so that whether it is 2 years or whether it is 3 years, if it is 2 years, then you still have the reports that will be generated yearly to do the sentencing review. But you may want to consider what the Court of Appeal said to perhaps better tighten subclause 11. For the purposes of a review, in going on to subsection 12, AG, for the purposes of a review under subsection 11, I just wanted to say this in passing, AG. There is a decision of the Court of Appeal in a matter called Mukesh Maharaj and the Attorney General. That is an authority that the advisors ought properly to look at, because unlike all of these cases that I am citing now that deals with the juveniles, Mukesh Maharaj was a case that was decided by Justice Kokaram at first instance, where he struck down the Offences Against the Persons Act that went to the Court of Appeal. So you have a decision that actually gives you a legal foundation for the purposes of this particular act, Mukesh Maharaj and the Attorney General. For the purposes of a review under subsection 11, the Commissioner of Prisons or the head of the institution in which the person is detained, as the case may be, shall annually, in respect of each year following the making of an order under subsection 11, I would have, under subsection 6, transmit the following documents to the Registrar of the Supreme Court. What section 12 does, it is that I was wondering if your advisors would go along with the idea of actually setting a date at when these things should be done. I can tell you, the prison never does it. That's the truth. It just slips through the cracks because there's nobody looking after it. So unless it's triggered by the actual accused, it's never done. Correct. So if we have a date, you could either do one of two things. You could either fix a date when these things are to be done, like I would have suggested yesterday. I told you I made these inquiries of Mr. Diaz, who is the head of operations at the prison. If we can fix a date, you could perhaps do it by regulation instead of doing it in substantive law, and regulate when they are to be submitted. And as a matter of this bears both on section 12 and section 13 AGs, that I would have thought that as a natural justice issue arises when these reports are generated. So you can improve on the legislation by simply adding to that copies of these reports are to be forwarded to the Office of the Director of Public Prosecution, as well as to the attorneys acting on behalf of the accused, so that you don't it does one of two things. It saves judicial time when you go to court, and then the court has to order that the reports be produced and sent to the other side, and you also send it to the Director of Public Prosecution. So as the legislature in charge of it, you do both sides and you fix the natural justice issue on that. So I would have thought that that is something that you can fix either in section 12 or you can fix it in section 13, and whichever way seems neater to your draftsman. In relation to B, AG, you have taken a very forward-thinking step in this legislation with respect to your improvements with respect to the insanity plea of having 2 medical practitioners give a report to the court when someone is held to be not able to plea to a criminal indictment. One of the difficulties that we have as practitioners is that you have no psychiatrist assigned to the prison, and when you ask for an up-to-date medical report, you will get a document that is signed off by the prison medical officers that it's fit and well, which says nothing. Those persons like Senator Samuel and Senator Raful, who would have been a part of a GSC that deals with the prison, would understand what I'm speaking about. I think that we need, for the purposes of this legislation, to specify that we need a medical report from a psychiatrist or someone of that field, so that we tighten it, because fit and well is not going to serve the court or the accused in any manner that could be beneficial in reviewing their sentence. What you have, AG, is that I see what you've done is that you've said assigned to the prison or the institution where the person is detained. The actual practice is that when these persons, whether they be under the offences against the person or under the Children's Act, come before the court automatically makes an order for a probation officer's report to be done, and you may want to consider, AG, that in line with your improvements on the plea bargaining legislation, where you've made specific statutory provision for victim impact statements to be done as part of that legislation, in the matter of Leroy Andrews and the state, which was the murder of Dr. Narayan Singh. In that matter, the victim impact statements were done for the first time in our jurisdiction with respect to a juvenile. And perhaps what you may want to do is to also import into the legislation the idea of providing that a victim impact statement be done as coming from the victims through the Office of the Director of Public Prosecution. I think too often we forget about the victims in these types of cases, and I think this is an ample opportunity for us to allow them some type of statutory footing to have some input in the review of these persons. I can tell you that in the, as you would know, what the country went through in relation to the Chokatin matter, with the nature of that murder, that the family of those persons, Gomes family, they wanted to play a part in the sentencing hearing because of the very vicious nature of that particular killing. So I don't think that we should take the opportunity to actually put a right in here for the victims. I don't see that there's anything wrong in us providing for them. I support you on the omnibus provision on the 12 subsection 3, and I think it preserves the right of the court to make any orders that would cater to any other information that may suit the particular circumstances of any particular case. The other issue that I wanted to raise with you, AG, in relation to 12 and 13, is that when you put these kinds of responsibilities on public officers like the Commissioner of Prisons or the head of an institution, they will automatically be subject to judicial review. And therefore, you don't want to just have these judicial reviews coming up time and time again, compelling them to do what they have to do in law. So that if we could find a mechanism to be able to fix a time, it will also prevent you from having to face those types of actions and to defend them, because most of the times they're indefensible. I would have thought that one of the other things, I can tell you this from a very unfortunate experience. In the matter of Harun Khan, that was the case that decided the constitutionality of the Jury Act, when we had the in-between period as to when the mandatory death sentence was declared to be discretionary. One of the cases that was decided by Lord Bingham on the same day that Rudal was decided was the case of Harun Khan. Harun Khan, because the death sentence was discretionary at the time, was ordered to be resentenced by the High Court. And it took 12 years for the Registrar of the Supreme Court to list for hearing an order of the Judicial Committee. 12 years. When Harun Khan was actually sentenced by Justice Jack, he was sentenced to a period of time that allowed him to sue the state for 6 years on lawful detention, pursuant not to anything done by the Commissioner of Prisons, Minister of National Security, but because the Registrar of the Supreme Court failed to obey an order of the Privy Council. So, in order for us not to have a situation like that reoccur in relation to 14, it would be very unfortunate for us to provide all of this. And what we should perhaps say is forward it to the Chief Justice, who shall assign a judge of the High Court to review the matter as required under Section 11 within 28 days from receipt of the reports, or something to that effect, so that you have a mandatory obligation within a limited time frame for this review to be fixed. Because it could be forwarded, lost in a file somewhere, and you have somebody suing the state after that for it not being listed, and they're just there in breach of 4A, 4B. Yeah. So that I would suggest that those are my suggestions, AG, in relation to how we can improve your very well thought out version of Section 4A.
May I reply, Mr. Vice President?
Honourable members, I just want to, at this point, indicate, based on the extensive suggestions that Senator Ramdeen has made, that we invite at this point other senators who wish to make any comments on this particular clause, which I would invite the Honourable Attorney General to respond, and then we would decide as to whether we want to defer Clause 3 at that point and move on to Clause 4, inviting suggestions as well. The comments were quite extensive going through each sub-clause, and I'm not sure, Honourable Attorney General, if you want to take some time to digest what was said, and we can proceed at that point to determine exactly how we would move forward. So I just want other senators to make comments on this particular clause before we move forward, and then I would invite you to respond to all.
If you would perhaps consider, I'd like to make some initial observations which may assist honourable senators in their fulminations, because Senator Ramdeen and I have a rather sharper focus in law than this is in no way to be an offence to anyone else, but it's really a matter of lawyering going on. So just a few quick observations and then to open the floor.
Go ahead.
First of all, again, to thank the honourable senator for very well thought out observations where he has brought the strength of his practice into consideration. We have been looking in particular at the prisons in a very deep and progressive exercise, and we're seeking to do the operationalization of the prisons rules to address in particular the matter of persons with disabilities, mental or otherwise, in the prisons. The Government of Canada has actually taken us very far in that approach, and we propose to actually conclude a report at the end of this month on how we're going to deal with these things. Whilst we've been dealing with the children's aspect of prisons as well, we have been factoring how we treat with these very unusual ranges and exceptions, and in particular about the medical attention. So far, you're right, the doctor actually turns up and you get this obscure sort of expression, and the mechanism that we're about to bring forward in regulations to the Parliament, one of which is for affirmative resolution, in particular in relation to children, but which is meant to apply to the adult section as well, is the provision of specialist medical circumstances, so that you no longer rely upon the public officer who is hardly ever there, as a matter of fact, and instead you import the specialist services. We've found that the specialist services don't want to attend or work on the prison's roster. So what we do is we have to find a mechanism to take the patient there to take the review. The issue of regulations is quite persuasive. Off the cuff, I'm wondering if the regs which we're working on right now on the prison side through the Ministry of National Security, as cleaved between children and adults, may pick it up, but I can see the merit of the Attorney General having some form of input into this end here. I'd like to say that, or rather remind that we propose to treat with the Section 59 of the Children's Act in the separate point, which will pick up a lot of these. We're actually far advanced on their end. The adult section has been lagging behind, largely because most people don't really pay attention to this particular pool of personalities, and so they tend to be the forgotten in society. Mr. Vice Chair, Mr. Chairman, what I propose is to have reflection upon the literature and submissions made. They're not very difficult things to factor. They are certainly steps in terms of improvement. It's just a balancing act right now between the specificity of doing it and the risk of providing for something which cannot be done. Not that one ought to develop law that way, but we're also factoring the state and play and condition of where we are. So I propose, subject to the inclusion of other observations, that we defer Clause 3. In fact, subject to the Senate's will, through your guidance, Mr. Chair, what I'd very much like to do is to continue on in the observations of the other clauses. Our best case scenario, insofar as we're here for the day, for me, subject to the will of the Senate through you, both in the higher chair and in the lower chair, is that we can perhaps work on it whilst we are doing other work in the Senate, and if necessary, reconvene on the matter, not to take away the work of the learned leader of the House or the coordinator and the chief whip, leader of opposition business. But I prefer to get the omnibus considerations. I think we've come a very long way in suggestions for improvement, and then to factor those whilst we have the break of perhaps some other work, and then to come back to this if it meets with the will of the Senate through you, Mr. Chair.
I think that is a good suggestion. It's something that I was actually going to propose after you had made your comments. Is that, Senator Mark?
Thank you, Mr. Chairman. Attorney General, having regard to what you have submitted and having regard to the depth and breadth of the various suggestions that have been proffered thus far, and if we are to do justice to this exercise, may I respectfully submit for your consideration Standing Order 66, subsection 3, where we can refer this matter to a select committee of this House, and we give this committee 5 to 7 days to work in this committee and report back to us, because I believe, Mr. Chairman, there are very important submissions that we have heard today, and because of how we are going to flow, we may not have the time to really do justice to these provisions or submissions, properly speaking. But if we were to refer this matter to a select committee of this Senate, and we give that select committee 7 days in which to report, not progress, but to submit their report for us to take a decision, I believe we'll be doing more justice to the process than if we were to defer, go on to some other matter, and then come back sometime later on. So that is my respective submission to the Attorney General for his consideration.
Yes. Mr. Chair? Okay.
Senator Mahabir?
Yes, thank you very much, Mr. Chairman. Mr. Chairman, I think the issues raised this morning are very involved. And I know the Attorney General is not one to make the law as we go up. This is a serious matter, and I too would like to endorse the sentiment of Senator Mark with respect to 66.3. And I think if there is a select committee of the Senate to consider not only Clause 3, but particularly Clause 3, but the committee, but the bill as a whole, and we report next week, Tuesday, after full deliberations this week, I think it would be a more efficient use of Senate time, and we would have next week an opportunity to have ironed out a lot of these legal issues, so that when the bill comes before us again, we would be in a much more secure footing with respect to our agreement or disagreement with the clauses. From my own perspective, I would like to indicate to the Attorney General that I would like to forward to your drafting team some of the word changes that I would like to make. I could have a track change so that we could tighten up the words. That's what I can do. But with respect to the legal fulminations, I really think the matters are so serious and the public interest would be best served if that select committee could be convened and we report next week. Thank you very much.
Attorney General? Or Leader of Government Business?
I have consulted with the Attorney General, and he is in fact convinced of your arguments, and we want to suggest that we form the Select Committee of the Senate. They will report next week Tuesday as a report, and then we will use that report, and we will hopefully reconvene the committee stage of this bill next week Thursday. Does that meet your approval, sir? Okay, thanks a lot.
May I thank senators for their thoughts and suggestions, which are very warmly received. I think it makes for very good progress. It allows us to get the views of some of the third parties that have to work with the system as well. So thank you, Senator Mark and Senators Mahabir, for that suggestion. Yeah, and we'll form that committee now and give the direction. And
Honourable members, taking into account the suggestion just made in regards to a select committee, what I will do is suspend this committee for 15 minutes, and we'll come back in 15 minutes. We'll make a decision on that. Thank you.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
Every year on June 12th, the International Labour Organization recognizes World Day Against Child Labour. We asked the question, what do you think child labour is?
I think child labour is having a child under the age of 16, working, and they're being deprived of that opportunity to be at school during the course of the day.
Any child employed under the age of 16 years is considered child labour. According to the laws of Trinidad and Tobago, there's an act entitled Minimum Age for Admission to Employment Act, 2007. And Section 4 of that act says clearly that no child under the age of 16 years shall be employed.
Child labour is exploitation. Child labour is taking advantage of scarce resources, impeding the rights of very young people to become productive and evolved citizens.
But child labour is exploitation of children. You know, using them for your own gain, to make money. You might see it as helping out. You have helping out and have working.
To me, child labour is exploiting the age. I think that is from probably 18 years that one individual or a child should be in a workplace. I mean, we stand for that. So having a preteen in a workplace, that is to me is exploiting child labor.
Well, my opinion on child labor is null and void, right? Because I find when a child is around the age of 14, 15, they should not be on the labor force.
No child should be forced into labor. The body wouldn't be able to handle the stress and the torment are working every day. Or a person, an adult, will handle the stress of work. A child mentally wouldn't be able to cope with that kind of stress.
According to the International Labour Organization, child labour is often defined as work that deprives children of their childhood, their potential, their dignity, and is harmful to their physical and mental development. In Trinidad and Tobago, the legal age for employment of young persons is 16 years. But not all work done by children should be classified as child labour. In fact, helping parents around the home, assisting in a family business, apprenticeship or on-the-job training programs, any after-school or weekend job, once children are not deprived of the opportunity to attend school and the work does not present a hazard or threat to the children, is not regarded child labor. Many of us associate child labor with images of children in sweatshops in poverty-stricken conditions, and whilst this may not be the reality in Trinidad and Tobago, it does not mean that child labor does not exist. Protect our future generation. Protect our nation's children. Say no to child labor.
Say no to child labor.
End child labor now.
Say no to child labor.
Say no to child labor. Say no to child labor. No to child labor.
I say no to child labor.
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 I would say no to child labor.
A message from the Ministry of Labour and Small Enterprise Development.
This has been a presentation of the Parliament Channel on Parliament Radio 105.5 FM.
Knowsley was once home to one of Trinidad's wealthiest men and remains an important part of our built heritage. The building was a sedate home compared to the ostentatious architecture of the Magnificent Seven. But its understated elegance and enviable position on the southern side of the savannah make it a very special building indeed. Gordon moved to Trinidad from Scotland when he was 17 to seek his fortune. He worked his way up from bank clerk to opening his own firm, Gordon, Grant & Company. His company offered loans to French Creole planters, using their estates as security. The French Creoles' extravagant lifestyles and the fluctuating cocoa markets led to Gordon Grant & Company's foreclosing on many estates. Tight-fisted William Gordon made up for his lack of social status by being stern and unforgiving in his dealings with the French Creoles, acquiring large land holdings, including many coconut and sugar estates. He stepped up the social ladder by marrying local royalty Gertrude Bush, the daughter of the colonial secretary.
A wealthy man like that would wish to project his success and his wealth by building a grand mansion in what was becoming a very posh part of Port of Spain, the area around the Queen's Park Savannah.
It was built around 1904, the same kind of time of that Stolmeyers and Whitehall and all these other buildings were built, because the cocoa barons were all competing with one another really as who could build the grandest house and etc., and showing off what they could do and how much money they had.
Gordon hired the British firm Taylor and Gillies to build his town home. The same firm built Stollmeyer's castle. The Italian and German design of the architecture showed much more restraint than the extravagant excesses of the houses built around the savannah at the time. The home was designed in a neoclassical style made up of a combination of local and imported material. Costing $100,000, the house was partly made up of limestone quarried from Laventille.
Yellow brick was imported from Britain. You find that a lot of the brickwork in the traditional Trinidad houses were used as ballast in the ships that came in to be able to take sugar out. So when they came to Trinidad, I mean, they no longer needed the ballast. They were sold, given to for construction. And this is where a lot of the yellow bricks came from.
You had also imported acid etched glass on all the ground floor, windows and doors.
Marble was imported from Italy for the veranda, and the regal staircase was made from Guyanese purple heart. Handcrafted gesso work was done by Italian craftsmen, and the ground floor ceiling included plaster of Paris details. Even though the house was built at great expense, much of its decor is beautifully understated.
I think one of the most important aspects of the building is, as I say, it's very tropical colonial in style. And you can see the development from, as I say, the small houses. You can see them in Woodbrook, you can see them in Belmont, which are like very small versions of this magnificent house.
The completed house was the result of local labour and craftsmen working with contractors who were often Scottish. The name Knowsley is believed to have come from Lord Derby of the Knowsley estate in Cheshire. William Gordon Gordon lived in the grand home until his death in 1919. The Ministry of Foreign Affairs purchased Knowsley in 1956 for $250,000. The stately building has also been used to host presidential events since the partial collapse of the President's House in 2010. Knowsley is a fine example of how our heritage buildings can be maintained and preserved for our generation and many generations to come.
The Joint Select Committee on the Cybercrime Bill is calling for public comments. The new bill seeks to regulate the misuse of computer systems, provide for the search and seizure of computer systems and computer data, and empower the court to order an internet service provider to produce information about a person who subscribes to its service. The bill is available on the Parliament's website at www.ttparliament.org. Written submissions should be addressed to the Secretary, Joint Select Committee on the Cybercrime Bill 2017, Office of the Parliament of Trinidad and Tobago, Levels G to 9, Tower D, International Waterfront Centre, 1A Wrightson Road, Port of Spain. Submissions can also be emailed to jsccybercrime@ttparliament.org. The deadline for submissions is Friday, June 16, 2017 at 4 p.m.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM. You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
The Joint Select Committee on the Cybercrime Bill is calling for public comments. The new bill seeks to regulate the misuse of computer systems, provide for the search and seizure of computer systems and computer data, and empower the court to order an internet service provider to produce information about a person who subscribes to its service. The bill is available on the Parliament's website at www.ttparliament.org. Written submissions should be addressed to the Secretary, Joint Select Committee on the Cybercrime Bill 2017, Office of the Parliament of Trinidad and Tobago, Levels G to 9, Tower D, International Waterfront Centre, 1A Wrightson Road, Port of Spain. Submissions can also be emailed to jsccybercrime@ttparliament.org. The deadline for submissions is Friday, June 16, 2017 at 4 p.m.
Every year on June 12th, the International Labour Organization recognizes World Day Against Child Labour. We ask the question, what do you think child labour is?
I think child labour is having a child under the age of 16 working, and they're being deprived of that opportunity to be at school during the course of the day.
Any child employed under the age of 16 years is considered child labor. According to the laws of Trinidad and Tobago, there's an act entitled Minimum Age for Admission to Employment Act, 2007. And Section 4 of that act says clearly that no child under the age of 16 years shall be employed.
Child labor is exploitation. Child labor is taking advantage of scarce resources, impeding the rights of very young people to become productive and evolved citizens.
But child labor is exploitation of children. You know, using them for your own gain, to make money. You might see it as helping out. It have helping out and have working.
To me, child labor is exploiting the age. I think that is from probably 18 years that one individual or a child should be in a workplace. I mean, we stand for that. So having a preteen in a workplace, that is to me is exploiting child labor.
Well, my opinion on child labor is null and void, right? Because I find when a child is around the age of 14, 15, they should not be on the labor force.
No child should be forced into labor. The body wouldn't be able to handle the stress and the torment are working every day. Or a person, an adult, will handle the stress of work. A child mentally wouldn't be able to cope with that kind of stress.
According to the International Labour Organization, child labour is often defined as work that deprives children of their childhood, their potential, their dignity, and is harmful to their physical and mental development. In Trinidad and Tobago, the legal age for employment of young persons is 16 years. But not all work done by children should be classified as child labour. In fact, helping parents around the home, assisting in a family business, apprenticeship or on-the-job training programs, any after-school or weekend job, once children are not deprived of the opportunity to attend school and the work does not present a hazard or threat to the children, is not regarded child labour. Many of us associate child labour with images of children in sweatshops in poverty-stricken conditions, and whilst this may not be the reality in Trinidad and Tobago, it does not mean that child labour does not exist. Protect our future generation. Protect our nation's children. Say no to child labour.
Say no to child labour.
End child labor now.
Say no to child labor.
Say no to child labor.
Say no to child labor. No to child labor.
I say no to child labor.
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 I would say no to child labor.
A message from the Ministry of Labour and Small Enterprise Development.
In an era of remarkable women in politics, Audrey Jeffers was arguably the most remarkable. In the 2 decades leading to universal adult suffrage in 1946, she stood tall as a feminist pioneer, advocate for working women, and a path-breaking politician. In 1913, at age 15, Audrey Jeffers went to London to study social sciences and got deeply involved in progressive movements, championing the rights of working women, especially black women. 7 years later, she returned home to a country in the grip of social strife and immediately got busy establishing the coterie of social workers. Today, more than 7 decades later, her pioneering support strategies for working women are as relevant as ever. Breakfast sheds for the working poor in locations across the country. The first school feeding program for children in and around Port of Spain. A home for blind women. City accommodation for rural women coming to work in Port of Spain. Daycare centers for working mothers. Scholarships for girls. A rest home in Togo for tired working mothers. And these are just some. With her popularity soaring, Audrey Jeffers ran in the 1936 municipal elections and made national history as the first woman politician ever to be elected. 10 years later, she would make history again as the first woman to be appointed to the Legislative Council. By then, however, Audrey Jeffers was at odds with women leaders of the working class movement and with progressive politicians in general. The break had come when, as a member of the Franchise Committee, she voted against universal adult suffrage.
It is one of the, in a way, unfortunate things of her history that she voted against universal adult suffrage. She had a famous statement, "We must hasten slowly." And even though she was such a wonderful person and so
The Honorable Vice President.
Honorable Attorney General.
We're still in committee, forgive me. Mr. Vice Chairman, Mr. Chairman, we are proposing that we continue on with the business of appointing a special select committee of the Senate in accordance with the standing orders. I think procedurally you would require us to resume the sitting of the Senate to appoint that committee, and so I ask that we undertake that process to move the relevant motion.
I will now suspend this committee and resume with the proceeding of the Senate. Attorney General.
Mr. Vice President, in accordance with Standing Order 66.3, I beg to move that a bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters be withdrawn from the Committee of the Whole Senate and be referred to a special select committee of the Senate to consider and report on the bill, and that the committee be required to submit its report to the Senate by June 20th, 2017. Forgive me. I also beg to move that the following members be appointed to serve on the committee: Mr. Clarence Rambarat, who will serve as its chair, Mr. W. Michael Coppin, Mr. Daniel Dukey, Mr. Gerald Ramdeen, and Mrs. Sophia Choate, SC.
Honourable Senators, the question is that a bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters, be withdrawn from the Committee of the Whole Senate and be referred to a special select committee of the Senate to consider and report on the bill, and that the committee be required to submit its report to the Senate by June 20th, and that the following members be appointed to serve on their committee: Mr. Clarence Rambarat, Chairman, Mr. W. Michael Coppin, Mr. Daniel Dukey, Mr. Gerald Ramdeen, and Ms. Sophia Choate, SC. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Motions.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, I beg to move the following motion standing in my name. Be it resolved that a joint select committee be established to consider the first report of the committee established to review the levels of healthcare delivery by the Regional Health Authority and to rationalize the system of public sector doctors in private practice, as well as the second report of the committee to review the levels of healthcare delivery by the regional health authorities and to rationalize the system of public sector doctors in private practice, laid in the Senate on November 15, 2016 and March 28, 2017, respectively. And be it further resolved that this committee be mandated to review and analyze the reports, consider the findings and recommendations contained in the reports, and thirdly, report its observation and recommendation no later than June 30th, 2017. Mr. Vice President, this Parliament has successfully used the Joint Select Committee system to evaluate and fine-tune and to reach consensus on legislation, especially complex legislation. I think we have a good track record in that regard. The new standing orders provide, and also the old standing orders, for standing joint select committees, which is the public accounts and other such committees, and then the new ones, which are the departmental joint select committees, which is the Committee on National Security, on Energy, etc., etc. This motion calls for the establishment of a joint select committee to review and analyze a major policy document as distinct from a joint select committee analyzing legislation that has been tabled in the Parliament. Today, Mr. Vice President, we propose to establish two such committees subject to this first motion on the healthcare system, and later on I will be moving the motion on setting up a similar committee for the draft development strategy 2016 to 2030, more popularly known as Vision 2030. Further, Mr. Vice President, just to inform the public and this House, that tomorrow in the House, I will be tabling the long-awaited Gas Master Plan. A pioneering move, if I should say so myself. Because under Dr. Christopher Rowley, the Prime Minister of Trinidad and Tobago, we are committed to make this government a government of transparency. Prior to the Rowley administration, Mr. Vice President, reports of this nature may have never found its way to the Parliament. And I want to compliment his leadership in that regard. Mr. Vice President, healthcare has always posed a challenge, and if I should say so, a serious challenge to Trinidad and Tobago, independent of which party is in power. And let me repeat that. Healthcare has always been and continues to be a challenge facing Trinidad and Tobago, despite pumping significant billions of dollars over the years. And that situation in the healthcare system is independent of which party is in power. This report attempts to provide solutions and recommendations to the many challenges that plague the healthcare system. Mr. Vice President, for the records, on November 15, 2015, immediately on assuming government, the Office of the Prime Minister established this committee. The committee's mandate was to review the level of healthcare delivery by the Regional Health Authority, and also to rationalize the system of public sector doctors in private practice. And I make the point, Mr. Vice President, the Prime Minister saw this as such an important issue that the cabinet note that formed this committee did not come from the Ministry of Health, nor the Minister of Health. It came from the Office of the Prime Minister. It was a committee that reported directly to the Prime Minister. And it was prime ministerial intervention that resulted in the formation and the implementation of this public policy matter. The committee comprised of 7 distinguished Trinidad and Tobagonians. It was chaired by Mr. Winston Welch. It included Dr. Wayne Frederick, Professor Carl Theodore, Mr. Martin Digans, Dr. Adish Surju Singh, Mrs. Valerie Alain Rollins, and Dr. Albert Prasad. They've spent many hours, they did many consultations, and they used their collective knowledge and wisdom and intense and deep understanding of the healthcare system to come up with this report. The committee produced 2 reports, a first report and a second report, as was stated in the preamble to the motion. The report is very detailed and very involved. The JSC will be mandated to study them, consult on them, approve or disapprove with their recommendations, and report back to the Parliament. Mr. Vice President, there has always been a clamor in the Senate, both by the opposition and by the independents, and rightfully so, for the Parliament to be more involved in policy formulation and policy evaluation, as distinct from the end product, which is a piece of legislation. I want to say here this afternoon, that this is your opportunity today. And I advise you to grasp it with both hands. So it is in this context, Mr. Vice President, I hope members on all sides will support this motion to take the so-called Welch report to a joint select committee. I think and I firmly believe that this is a step in the right direction. Mr. Vice President, I beg to move.
Who's next? Yes, my bad. Honourable members, I shall now propose a question for debate. Be it resolved that a joint select committee be established to consider the first report of the committee established to review the levels of healthcare delivery by the regional health authorities and to rationalize the system of public sector doctors in private practice, as well as the second report of the committee to review the levels of healthcare delivery by the regional health authorities and to rationalize the system of public sector doctors in private practice, laid in the Senate on November 15, 2016 and March 28, 2017 respectively. And be it further resolved that this committee be mandated to review and analyze the reports, consider the findings and recommendations contained in the reports, and report its observations and recommendations no later than June 30th, 2017. Senator Ameen.
Thank you very much, Mr. Vice President. Mr. Vice President, I thank you for this opportunity as I rise to make a contribution to this motion moved by the Leader of Government Business in the Senate on the first and second reports of the Committee to review the levels of healthcare delivery by the regional health authorities and to rationalize the system of public sector doctors in private practice in Trinidad and Tobago. Mr. Vice President, I want to begin by reiterating that the opposition is of the firm belief that the public health sector in Trinidad and Tobago is in a critical condition and needs special attention. The priorities of the public health sector was one of the priorities of the People's Partnership government, and we continue to support initiatives to improve public health care in our country. And today we have this debate at a time when in the national sphere, we recently had a pensioner who died on the grounds of the Port of Spain General Hospital, and conflicting reports from witnesses and from the Minister of Health. And I think the public is the one to judge on who is telling the truth in that matter. Mr. Vice President, I feel that this motion really is an attempt by the government to get the Parliament to do cabinet's work. Mr. Vice President, the Parliament makes laws and holds the government to account for its policies, its action, and its spending. The function of our Parliament includes, after the election, the forming of the government, the members of the executive who come from amongst those elected. The Parliament is responsible for making new laws, for updating old laws, for representing people, and those 41 constituencies whose members of Parliament sit in the House of Representatives are the voices of the citizens of our country. The Parliament should be examining and approving government's taxes and spending. And we have also had a lot of controversy in that regard because of the challenges we are faced with at this time. And when it comes to the country's resources and our limited revenue, the government has a responsibility to decide on priorities. And I am of the belief that because of those challenges in terms of the national economy, the government should be very clear on its policies and actions, particularly when it comes to public health care in Trinidad and Tobago. Mr. Vice President, there are some, in terms of ordinary citizens, the layman, who may believe Parliament and government is one. We in here know that the difference between Parliament and government. And the government, those on that side, are the people who have been elected to run the country. They are the ones whose political party won the majority of seats in the general election. They are in charge, but they are yet to take charge. You are in charge for 5 years until the next general election. It may be before the next 5 years at the rate you are going. Your leader is appointed Prime Minister. The Prime Minister would have chosen members to form his government, to form his cabinet. He would have chosen junior ministers as well. They are the ones, Mr. Vice President, who is responsible for making a plan and for deciding on policy. And this motion seeks to throw that responsibility on the Parliament. Mr. Vice President, a government cannot make new laws on its own or raise new taxes without the approval of Parliament. That is what Parliament is here for. And Parliament must agree in order for those things to happen. Parliament is here to represent the interest and to make the voice and the conscience of our citizens heard. The voices of our citizens must be taken into account by government when it is making new laws or updating laws. And a good Parliament reflects the conscience of our society. The government, on the other hand, is responsible for deciding how the country is run, for managing things, the day-to-day affairs. They are the ones who set taxes, and we have had a lot of new taxes in the last 20 months or so, Mr. Vice President. They are the ones who choose what to spend public money on. They have the responsibility to deliver on public service. And public service includes, in a large part, the public health sector and, in this country, the regional health authorities. But it also extends, of course, to the police and the armed forces, our national security and safety of our citizens, the social security of our citizens, our most vulnerable, and, of course, the revenue of Trinidad and Tobago. So this Parliament is being called upon to examine a report which the leader of government business indicated of a committee that was announced or commissioned on the 15th of December in 2015. Mr. Vice President, when I heard of that at the beginning of the government's term, I thought that the findings of this committee would inform the government and the cabinet of a policy, and thereafter, if it required any changes in legislation, that draft legislations, those proposals to change the existing legislation or to bring new laws, is what would come into Parliament. But what we have seen is the government abdicating its responsibility to decide on policy. Mr. Vice President, the Parliament operates as a check and balance. The Parliament has the opportunity to look closely at the government's way of running things. We have mechanisms for transparency. We have questions to ministers where cabinet ministers have a responsibility to answer questions from the opposition with regards to any matter. They can request information, and many times that is how the public would know of certain things that are taking place. And I just recall a news report on one of our national television stations showing a conflict recently based on a response from Senator, for a question asked by Senator Wade Mark on the situation with the 60-year-old pensioner who died in the hospital, on the hospital grounds. Hearing the response of the Minister of Health, indicating that no protocols were breached, and hearing in that same news report the accounts of the witnesses and other persons, such as the relatives and neighbors of that gentleman, may his soul rest in peace. And of course, that gives the public, through the Parliament, the opportunity to judge for themselves whether the government is acting responsibly. And in this case, I must say the verdict is out. The health minister has acted irresponsibly by tossing aside the verdict of the public and the responsibility to protect the citizens from that kind of treatment. Mr. Vice President, the rules of our Parliament allow us to be workable, to have collaboration, to be efficient, to look at legislation that is proposed and suggest changes. We just came out of a committee stage on a bill, because this is not a bill, on a bill where a number of suggestions were made from the opposition bench, from the independent bench, that would improve the proposed legislation. All of this is televised so that our citizens can follow and be involved. The role of the Parliament is to ensure that the new legislation is fair, that it is not discriminatory, that it complies with equalities and human rights laws, and the violation of any such rights should be taken up in a debate to protect the citizen at the end of the day. The leader of government business, Honorable Franklin Khan, began by commending the Prime Minister for this decision to send this report to the Parliament. While I say it is good that a report was commissioned to begin with, I want to indicate that it is my view that the Prime Minister is really throwing his responsibility and throwing the work of Cabinet onto the Parliament. This report that has been commissioned really ought to go to Cabinet. The Commission reports to the Prime Minister. The Prime Minister should sit with his Cabinet and do their work. We have heard, of course, and it was mentioned by the Honorable Franklin Khan, that very soon we will have debate on the government's 2030 vision, which should be articulating the government's plans. The truth is that this nation would have heard during the election campaign from all the political parties what their proposals were. And the government, those promises in that manifesto should materialize into government policy. And what we are seeing by this motion is a failure to do that. I want to implore the government that public health care in Trinidad and Tobago is critical. There are challenges that would take the term of a number of governments to be sorted out. And it requires continuity, it requires genuine commitment. The opposition, Mr. Vice President, will continue to act as a form of check and balance. We are not running this country. If the government wants the opposition to be part of making policy, then they should resign and call a general election and let the people decide. The role of the opposition is to act as a check and balance. Yes, the UNC is a government in waiting, and we have been witnessing failure after failure by the government when it comes to critical issues like public health care and national security and the economy. And this, Mr. Vice President, is the result of a lack of a plan. Almost 2 years into this government's term, their campaign promises are yet to become public policy. The Honorable Leader of Government Business did indicate that that is going to come. So 2 years down, you have 3 years left in your term, and you are going to bring this plan that will take some time, of course, to implement. There may be measures in that plan that would require legislative change, that would require infrastructure. When are you really going to start to govern this country? When are you going to start to act according to a clear plan? We are seeing incompetence clearly at work here, Mr. Vice President. There is a clear lack of political will to do the work that is required. It is either lack of political will or incompetence or
Mr. Vice President, on a point of order 46.1.
Senator, on the point of order 46.1, I rule that there is merit. I'm going to ask you to get back to the motion that's before us that speaks specifically to the establishment of a joint select committee in relation to the reports that are given. You've given some points in the beginning, and I think you're starting to also repeat those points. So I would ask you to move on to your next point, but keep it within the boundaries of the bill, of the motion. Thank you.
Thank you, Mr. Vice President. Mr. Vice President, unfortunately, the incompetence and lack of political will of the government has been repeating itself. And so the opposition has no choice but to repeat the highlighting of the failure of the government. But, Mr. Vice President, I thank you for your guidance. Mr. Vice President, a well-functioning cabinet should have a very clear plan as to what it wants to achieve. I am a firm advocate of consultations, consulting the public, consulting the experts, the technocrats, so that whatever proposals are made in terms of draft legislation would represent different schools of thought, different experiences, and so on. I am in support of reports informing policy, informing legislation. I am in support of inquiries, for example, to get to the truth, to get to the bottom of things, so that when policy and when laws come to before cabinet, when policy goes before cabinet, and if there are any changes that are required to the law, when it comes to Parliament, you have a well thought out piece of legislation before you. Mr. Vice President, I am of the view that rather than forming a joint select committee, the report should go to the Prime Minister and his cabinet. The cabinet should decide on the policy with regards to this matter. If the implementation of that policy could be done within the confines of the existing law, the government has the authority to implement those, that new policy. However, if the existing law restricts that policy in any way, then they are free to come to cabinet to ask for those laws to be amended or to create new laws. So, Mr. Vice President, we have seen a number of occasions where the opposition requested joint select committees to deal with issues where you had suggestions or the views that there would be infringement on human rights, for example, rights enshrined in our Constitution, laws that protect our citizens. We had the situation with FATCA. You had the situation with the SSA, where there was an issue of whether people had a right to privacy or not. And the opposition asked the government to form a joint select committee so that we could deal with those issues in the best interest of the citizen. They refused, Mr. Vice President. But today, we see before us not a bill, not proposal for new legislation, not even a policy. This is a report from a committee that should inform government policy. And I feel that the government is abusing the parliamentary system by bringing this and asking us to have a joint select committee on this. There are critical issues that are affecting our nation. Public health is one of them, and the government has to be more decisive, has to be more particular. I feel that this is an attempt by the government to postpone a decision with regards to, and particularly with regards to doctors in the public health sector operating in private practice, because that is a big part of the report, and that is a controversial matter, Mr. Vice President. You have doctors in the public health sector who claim that they are poorly paid. The conditions within our public hospitals are poor working conditions for our doctors, our nurses, and our allied health employees. On the other hand, you have very talented and gifted medical practitioners who have their private practice. So yes, they work in the public sector, but they have private practice. And there are those who end up crossing lines. And there are citizens who go to the public health facilities, the hospitals as well as the health centers, because of the delay, because of bureaucracy, because of poor management. They do not get the services, the health care that they require, and so they can be recommended by a doctor to come to his or her private practice. There are issues with regards to how ethical that is, but there is a controversial issue with regards to the fact that the hospital cannot provide the service, and the fact that these doctors have the ability to provide it privately. Are you proposing, the government should be telling us, are you proposing to pay doctors in the public health sector more as an incentive to operate only in the public health sector and eliminate their private practice. If a policy decision is taken to prevent doctors who are working in the public health sector from working in the private sector, it means that they will have a decision to make. And if they choose to stay in the more lucrative private practice, it means that there may be and there could be a shortage of doctors in the public health sector. So that is the decision that the government really has before it. And I feel that this response of bringing this report to the Parliament really is the government shirking that responsibility, shirking the authority, the responsibility they have to make that decision and at a policy level and throw it on the Parliament. Mr. Vice President, the issue with regards to the doctors in the public health sector operating in private practice is a matter that has to be decided by the government. Whichever political party forms the government, the issue with how these doctors operate should tie into the policies surrounding the public health sector. So it is not a one-off decision. It ties into the entire operation of the public health sector, the quality of service we want to provide. And the truth is that the public health sector has to compete with the private facilities. Is the poor management by governments of the public health sector leading to more lucrative business opportunities for health in this country? We have seen a number of private hospitals come up over the years. There are many people who may not even have insurance, but they make the sacrifice to take particularly their children or their elderly parents to a private facility. And that is an indictment on our public health sector. The People's Partnership did make a number of policy decisions. And again, I come back to the issue of government making policy decisions and not the joint select committee that is being proposed here. The policy decisions of the People's Partnership in some cases required legislative change. But there are a number of issues that, in fact, were a number of initiatives that were public-private sector partnership in terms of the solution. You had the decision for surgeries to be referred to private facilities and for the regional health authorities and the Ministry of Health to pay for that surgery so that our citizens would not be waiting. I recall as a councillor, local government councillor, a gentleman in St. Augustine South who had a serious heart condition and he had to get a test at Mount Hope Hospital. And he sadly passed away sometime during this year, late last year, sorry. But, Mr. Vice President, in the year 2016, he was given an appointment for 2018 to do that test. He passed away before that date. However, his family had to go to a private lab and pay to have the test done. As a part of the People's Partnership policy around health, those, the costs, the expenses for situations like that would have been borne by the government. And Mr. Vice President, that policy really was an incentive for the government to improve the public health sector in order to reduce that bill, that pain to the private sector. So the policies of the government must improve the services, the health services to our citizens, but it must also be in line with the existing laws. I look forward, Mr. Vice President, to participating in a debate, if one should arise, on any changes to our existing legislation or any new laws that would have a positive impact, that would improve the operation and the functioning of our public health care system in Trinidad and Tobago. But, Mr. Vice President, I see no need and no responsibility that is of the parliaments to decide on policy for the government. the government has indicated that it intends to bring their 2030 vision to the Parliament. They will do that subsequently, but that is a plan that they are putting forward. And I would like to see a firm plan coming out. I don't think the government should be saying to us, listen, this committee here, the Prime Minister commissioned this committee to do a report. The findings of the report would be very valid. And it is not the responsibility of a joint select committee to decide on what the government policy is. Mr. Vice President, I want to tell you, though, that the People's Partnership has a very as to what we want public health care in this country to look like. And the truth is that it would take more than one term in government to complete those things and to improve our critical healthcare systems. I trust that the good initiatives implemented by the People's Partnership will be continued by this government for the sake of our citizens, and as well as any new initiatives.
Senator, have a seat. I want to caution you at this point, because I'm starting hearing some points coming up again and again as you're making your contribution, and you're well into your contribution at this point. Secondary to that, I want you to stay within the boundaries of the motion as it relates, again, to setting up a joint select committee as it to look at these recommendations in the reports. So as you're making your points going forward, please keep it within that boundary.
Thank you, Mr. President. Mr. President, I am nearing my wrap-up, and in my contribution, what I sought to do was to highlight the responsibility of the Parliament, the responsibility of the government, and the failure of this government to do its job, as well as...
One second. You've made that point in
Yes.
the beginning, and you've made it in the middle. So what I'm asking you to do is to move on from that point. If you have any other points, by all means, go ahead. But at that point, in terms of the responsibility of government and the Parliament, you've made that point ad nauseum.
Mr. Vice President, I didn't know ad nauseum was against the standing orders, but I close my contribution.
Senator Ameen, sit. Tedious repetition is against the standing orders. So if you're making it ad nauseum, what I'm telling you is you don't need to continue to make that point. So can you just please, as I've ruled, move on?
Mr. Vice President, I thank you for the opportunity to contribute.
Honourable Senators, at this point we will take the lunch break. This House will now stand suspended until 1:55.